Hey everybody, welcome back to the Shanty. We're off to a good start in 2023, aren't we? 3 in a row. So, what are we doing in the Shanty? Well, first I got to give a shout out to somebody. The shout out I have to give out is to a guy named Daniel S. Brookins. Now, Daniel is a new associate at our law firm, and he is interested, he's a litigator. And he's interested in employment litigation. And as a result of that, he's sent a couple of emails out. Some of you might have read his e-alert that he and Amanda Fielder put out a couple of weeks ago about the Delaware Chancery Courts. But he sent out another email involving a Sixth Circuit case involving the FMLA that was very interesting. And I asked his permission to turn it into a shanty. It was an internal email. We didn't do an e-alert on it. And he graciously agreed. And so I'm going to give him full credit for this because I am ripping him off like you wouldn't believe. As a matter of fact, some of the things you're going to hear, I'm just going to read that he wrote, primarily because he's a brilliant writer and really seems like a nice guy. If I can figure out a way to do it, I'm going to put his contact information in here so you can go read his profile because you really should. And the guy it's impressive. So thank you, Daniel, and welcome to the firm. And with that in mind, let's talk about the FMLA and retaliation. And why is this case important? It's important because it reiterates a point that we have made all along regarding employees requesting FMLA leave. But it also points out an issue that you should be aware of when it comes to retaliation claims. There's a couple of things going on here. Now, we have said over and over, and you've heard me say over and over, in the Title VII context, in the ADEA context, an employee can file a suit under Title VII for, say, sex discrimination, lose their underlying lawsuit under the sex discrimination claim, and still win the retaliation lawsuit or count that goes along with that. And this falls into that sort of category. So the case involved a woman who worked for a very prominent law firm here in Michigan. And I'm not going to tell you the name of the law firm, but you've heard of them. But I will tell you the name of the case. It's Millman versus Feiger and Feiger, in case you're interested. Ms. Millman was an attorney for the law firm, and she had a son who had a heightened vulnerability to contracting COVID-19 because he had apparently some respiratory problems, according to the description in the case. So in mid-March of 2020, her son began to exhibit symptoms of COVID, and she was concerned about coming into the office. She didn't want to come into the office. So she had called and talked to her supervisor at least twice about this and assured her supervisor that she'd be in by March 19th. Well, March 19th rolls around. Her son is not doing any better. She's still concerned, so she contacts human resources at the firm, and she says that her son's symptoms were not any better and that she had major concerns about working in the office because of her son's condition, and she offered to take unpaid leave if necessary to stay out of the office. Now, that's important. Don't forget that. She offered to take unpaid leave. Now, HR didn't address her unpaid leave situation. HR just said, don't worry about it, you can work at home, or something like that. But they allowed her the option to work at home, which she accepted. Later, the very same day, she got a letter from the firm telling her she was fired. And the letter said, quote, "You assured your supervisor that you were going to come in on Thursday. You did not come into work and indicated that your child had a minor cold. Today will be your last day on our payroll," period, end quote. Shock of all shocks, Miss Millman sued. And she alleged, among other things, that she was wrongfully discharged in violation of the FMLA, that the law firm had interfered with her rights under the FMLA. Now, the district court, the trial court, the initial court dismissed her claim. And they dismissed her claim using the following rationale. First, they said, look, you didn't allege any facts that would support the fact that your son was suffering from a serious health condition under the FMLA that would create an entitlement for you to take leave in the first place. In other words, because you would not have ultimately been entitled to FMLA, your request for leave wasn't protected. They did what they called cabining her claim to a section of the statute, which is 29 USC 2615A2, reasoning that Sixth Circuit case law said that 2615A2 is the sole basis for retaliation claims under the FMLA. Now, what is 2615A2, you're asking? Well, section 2615 of the statute, not the regulations, the statute is the section that lists quote unquote prohibited acts. It's the things that employers are not allowed to do to employees with respect to the FMLA. And section A2 of that section says the following: it shall be unlawful for any employer to discharge or in any other manner discriminate against any individual for opposing practices made unlawful by this subchapter, period, end quote. In other words, what the court was saying was you weren't opposing an unlawful practice because you weren't entitled to leave, and as a result of that, you're not entitled to a retaliation claim. Your retaliation claim fails. Now, that's interesting, right? Because we have said, as I said at the beginning of this video, in the Title VII context, for example, you can lose your underlying discrimination claim and still win your retaliation claim. Ms. Millman appealed. She didn't like that outcome, not surprisingly. And the court went up to the Sixth Circuit. And the Sixth Circuit disagreed with the district court's reasoning on both levels, okay? First of all, the Sixth Circuit said it was wrong for you to cabin her claim to 2615A2. The court put it this way, quote, as we and other circuits have recognized, a retaliation claim may also be cognizable under 2615A1. Okay, what does 2615A1 say? Well, 2615A1 says, it shall be unlawful for any employer to interfere with, restrain, or deny the exercise of, or the attempt to exercise, important language, any right provided under this subchapter. Okay, so now the Sixth Circuit is saying, look, that section also can give rise to a retaliation claim. And because Ms. Millman said, I'm willing to take unpaid leave, that could potentially that's an attempt to exercise your rights, right? And that could give rise to a retaliation claim. So what the panel reasoned was is that also what the panel reasoned was is that in some cases, you actually have to be entitled to leave for your retaliation claim to be successful. And they used as an example for that, where the employee actually takes leave, gets fired, and then claims they were retaliated against. So if you take leave on false pretenses and you get fired for that, and the leave wasn't protected by the FMLA, then your retaliation claim isn't cognizable according to the court. But the court said, look, here she never took the leave. So that's not what we're talking about here. They said Millman never actually took leave. She only made a request for leave. So because the FMLA requires employees to make the request to initiate the statutory process, the request itself, according to the court, quote, must be protected activity under the Act. FMLA rights and the statute's purpose would be significantly diminished if employers could fire an employee who simply took the required initial steps to access FMLA leave, period, end quote. In other words, what the court says was, you're foiling the purpose of the Act if you're allowed to fire an employee who requests a leave, even though the leave might ultimately be denied. Now, that raises some big issues. And there was a concurring opinion in this case that helped frame those issues. That, the concurring opinion is not law. The majority opinion is law, but the concurring opinion here is very instructive. And the judge in the concurring opinion, I'm not even going to try to pronounce the judge's name. He kind of put some parameters around when an attempt to initiate the process is actually protected. The judge expressed concern for, quote, unrecognized, unmoored, unsuccessful attempt claims that could lead to uncertainty and possible abuses, period, end quote. That's for sure. In other words, anytime somebody thinks they're going to get fired, they can just request a leave, even though they know they're not entitled to it, and then make out a retaliation claim. And the judge was concerned about that. So what he did was offer some, as Daniel put it, guideposts to kind of rein this in a little bit and not make it so broad. First, the judge said the attempt, quote, must seek to accomplish any right provided by this subchapter. In other words, quote, attempts that unambiguously seek to obtain non-protected activities, like vacation, are not protected, end quote, and therefore are not retaliation. Second, the judge said, the attempt must provide sufficient notice, quote, and we only recognize notice as sufficient when an employee provides enough information for the employer to reasonably conclude that an event described in the FMLA has occurred, period, end quote. Now, did Ms. Millman do that? I think she did, because she had been talking to HR all along about her son's vulnerability to COVID-19 and his breathing problems. Breathing problems can be a serious health condition. Now, he may have just had a cold and therefore not been protected by the FMLA, but he might have had something more serious like COVID or long-haul COVID or RSV or something that could rise to the level of a serious health condition. And then the judge said, third and finally, an attempt ends when the employee actually takes leave. Because existing Sixth Circuit precedent requires, quote, employees with retaliation claims to prove that the FMLA protects any actual leave taken, period, end quote. So those are the three things that the judge put around this thing. Now, what I think is important about this case is a number of things. Number one, it does kind of open up the retaliation book to employees who just ask for leave. But it probably doesn't do that in a way that's unleashed and anybody could just ask for a leave and be protected. But the other thing it does is point out to something that we've been telling you here for a long, long, long time. And if not here, in other places that we've spoken, in our seminar and all that. And that is when an employee makes a request, like she did here, to take unpaid leave, you have an obligation to determine whether or not that's covered by the FMLA or may be covered by the FMLA and initiate the process. Okay? In other words, you've got a duty to inquire, right? The employee doesn't have to say FMLA, and that's clear from the regulations. All they have to do is say, I need time off for my sick son, and a duty to inquire as to whether or not the sick son might have a serious health condition that requires you to give FMLA leave. Thanks a whole bunch. Thanks, Daniel. I appreciate it. We'll see you all guys all next time.